We're going to go ahead and have Senator Hatchett get us started. Representative Gillett, could you open us up in a word of prayer first to start our day?
Bow your heads, Father God. Thank you for this day. Thank you for the ability to be here. Give us the guidance and prudence to do this job well. Let us do it for the state and do it for the right reasons. In your name we pray, amen.
Thank you, Representative Gillett. Always good to have my fellow compadre from Paulding County here with us this early. Well, we got three lawyers with us this morning. Senator, tell us about your bill and let us know which LC number you're working off of.
Thank you, Mr. Chairman. This is Senate Bill 44. It's LC number 480927 ECS. And if it's okay with the chairman, I've got Kara Convery and John Fowler with the AG's office here to help with any questions y'all might have. But I bring the substitute to Senate Bill 44. This substitute does three things. First, it goes after criminal street gang members that seek to harm our children. Two, it makes an important clarification in code to properly reflect the definition of street gang activity. And three, it codifies best practices of judges across our state regarding OR bonds. Governor Kemp has made tackling criminal street gangs a priority since the beginning of his administration. Through listening to local law enforcement and prosecutors, and with the help from the legislature, the governor has championed one of the strongest criminal street gang statutes in the country, created the Gang Task Force at GBI, and added the Gang Prosecution Unit to the Attorney General's office. Building on his promises, the governor, in partnering with the Attorney General and the Lieutenant Governor, seeks to continue to crack down on criminal street gangs by giving prosecutors the tools to go after known gang members and protect children in our state. This bill seeks to establish a mandatory minimum sentence of 5 years for those in violation of the criminal street gang statute in order to crack down on individuals that perpetrate these crimes. The bill provides district attorneys, the Attorney General, and judges with tools that will help infiltrate these criminal organizations and bring more gang members to justice. Senate Bill 44 also adds enhanced penalties on gang members that recruit children into their criminal enterprise. The governor's office has been informed of the rising occurrence of gang members targeting children for criminal street gang recruitment. This past November, the governor and the Attorney General announced an indictment of 17 alleged gang members in which, among other crimes, gang members were recruiting young children by using family-friendly events. While all efforts to combat criminal street gang activities have had a tremendous impact throughout the state of Georgia, more must be done to keep our children away from a life of crime and keep our community safe. Through this bill, the governor's office wants to send a strong message to gang members. If you come after our children and endanger our communities, we are coming after you. Senate Bill 44 also makes a needed clarification regarding gang offenses as bail-restricted offenses. Currently, participation in criminal street gang activity is a bail-restricted offense. However, our code defines criminal gang activity and criminal street gangs, but not criminal street gang activity. So to avoid any confusion, criminal street gang activity is corrected to criminal gang activity. Coinciding with the effort to crack down on crime, the governor's also seeks to add two very straightforward, practical changes to Georgia's unsecured judicial release statute by codifying what should be regular practice amongst our judges today. First, it provides that a judge may not issue an unsecured judicial release on the basis of his or her own recognizance, or OR, which is just a signature bond, if the accused person has previously been convicted of bail jumping or has otherwise failed to appear in court in the last 5 years. Again, this only applies to an unsecured judicial release that is issued on a person's own recognizance and does not affect the judge's ability to issue an unsecured judicial release for the purpose of pretrial release or diversion. Now, bail jumping is a criminal offense for failing to appear in court. However, that charge is not always or often pursued. In practice, if a person fails to appear in court, the judge should, at the end of the day, forfeit that person's bond and issue a bench warrant for their arrest. For that reason, the bill was drafted to reflect this practice as the indicator for an instance in which someone has previously failed to appear. These provisions shall not apply on the basis of a person's failure to appear for a non-serious traffic offense. What we're trying to do here is make sure no one gets an OR bond that has a pattern of not showing up for court. Second, the bill makes clear that prior to issuing an unsecured judicial release, a judge must consider the accused criminal's history information. Right now, that's what judges do. It's just not in our code. And to be clear, this consideration does not preclude a judge from issuing an unsecured judicial release. Rather, it ensures the public that before any offender is released without any security tied to his or her subsequent return to court, the judge will, at the very least, have reviewed the most relevant information applicable to his or her bond determination. With that, Mr. Chairman, I'm happy to answer any questions. Obviously, this is a bill that I'm bringing on behalf of Governor Kemp, and it's going to protect the children and help give police officers and judges and prosecutors the tools they need to continue to fight gang activity in the state.
Thank you, Senator Hatchett. It's always good to have you with us. You always do a good job on presenting your legislation. Let's see, number 8, is that Representative Miller?
It is. Thank you, Mr. Chairman. Good morning, Senator.
Good morning.
Thank you for your work on this bill. I do appreciate the sentiments behind it. Obviously, caring for children in the community who are being recruited by gangs. I guess my question is, will you agree that the gang statute is fairly broad and robust as it is written?
As it's currently written?
Yes. Okay. And that Georgia is somewhat of an outlier state in that we even have a gang statute. Lots of states don't. They just use it as sort of a sentencing enhancement if you participate in gang activity or if the crime is gang related. You're aware of that?
If I'm not aware of other states' laws,
Okay. And your changes today, if I understand them, would make certain things, certain crimes committed under the statute have mandatory minimum sentences, namely if a person recruits someone under 17.
That's correct.
Okay. Are you aware of any research or data that would suggest that mandatory minimums actually deter people from committing crimes?
What I'm aware of is a problem in the state of Georgia right now where gangs, the lifeblood of a gang is recruitment. And they are recruiting our children to join their criminal enterprises. One of the reasons that they are recruiting children is because the juvenile justice system is not as strict. So when a child gets caught breaking into a vehicle or gets caught with drugs, more than likely they'll be back in a couple days. It's cruel, it's wrong. Our children are very vulnerable, and a 10-year mandatory minimum for recruiting a child into a life of crime, I think, is appropriate.
Well, let me ask you this. Lots of kids join gangs and don't actually participate in any crimes. They're just members of a gang. You're aware of that, right?
No.
And that's actually not illegal, right? To be a member of a gang. It's not a crime.
It should be. It's going to be illegal to recruit a child into a gang after this bill passes.
I understand that's what the purpose of the bill is. I'm just asking questions.
Yeah.
Because the children who are recruited into gangs one week are the folks who are recruiting children into gangs the next week. And so there is not that big of a distinction between the 17-year-old who recruits his 15-year-old cousin to join what he is not even thinking about as a gang, but a social circle. That's often how it pans out in reality. Would you agree to that?
I think you may have done the research on this to suggest that. I don't know exactly how that works, but I know that we're trying to protect children in the state of Georgia from being recruited into criminal gangs, and that's what this bill is going to do.
Okay. And so would you agree also, though, that the children who are recruited into criminal street gangs are often children who do not have parental support, children who are not reading at grade level, children whose parents are not in their lives, who aren't going to school regularly, who have all kinds of other factors that are playing into whether or not they get involved in street gangs?
I think there are a lot of issues that need to be addressed, and one issue that we are addressing with this one is to deter and prevent adults from recruiting children into gangs.
Okay. And the question then becomes, what happens to, and the reason I'm asking this, and then I'll wrap up, Mr. Chairman, is that we have learned from history that mandatory minimums disproportionately impact Black and brown communities. You're aware of that, right?
I've seen those statistics, yes.
Okay.
Yes, I have.
And I would imagine that the prosecutor sitting next to you would concur in that most of the individuals that are prosecuted under this statute are Black and brown boys and men, young men, typically. You would agree with that, correct?
I can defer to the AG's office that's here with me on those statistics. You know, this bill is aimed at protecting children. I see where you're going with this line of questioning, but it is a policy of the governor's office to combat gangs and to make sure our most vulnerable citizens are not being recruited in. This is what this bill is attempting to do.
I understand. Thank you, Mr. Chairman.
So let me ask this, just to clarify, and we always glad to have former prosecutors on our committee. I think Representative Miller was one of the only one who's actually prosecuted a homicide on this committee, so appreciate that line of question. Let me ask you this. As far as gangs, this also be applied to those that are trying to recruit into the Hells Angels or the Aryan Brotherhood?
Yes, absolutely.
If you'll just identify yourself,
Yes.
come a little closer to the mic.
Yep,
if you
and
don't
good morning.
mind.
My name is Kara Convery. I'm here on behalf of the Attorney General's office in support of this bill. The question about whether or not this bill and all of its parts are applicable to gangs like Aryan Brotherhood, groups like the Ghostface Gangsters, certain motorcycle gangs are the ones that were referenced in the question. Absolutely, yes. This is another tool for prosecutors to use, and like anything else, it's a tool that prosecutors will have the option to use when it's appropriate to do so. I agree with Representative Miller, and as it pertains to the gang statute as it's currently written, it is particularly robust, does have a lot of tools. What it does not have is a lot of enhancements. Currently, right now, in the way the 1615-4 statute is written, leadership in the gang is a codified enhancement. This would serve to make recruitment into that gang a codified enhancement, which is the result of, unfortunately, what we see day in and day out. Similar to what the Senator said about lifeblood of these groups being the recruitment of young children. What it does not do is make these mandatory minimums applicable to juveniles. So although a juvenile could be charged with this offense, you would not follow the same sentencing structure as articulated for an adult offender.
Okay. Let me ask you this. Waylon Jennings, he always had, yeah, everybody knows who Waylon Jennings is here, I hope. Okay, anybody not know who Waylon Jennings is? Because I'm about to assign homework. Okay, so Waylon Jennings, this is just a hypothetical for you. Waylon Jennings always had the Hells Angels riding around with him, protecting him. That was his personal protection when he was out on the road now. I don't know that he ever joined them, but he didn't ever tell them not to go and protect him. So as far as that kind of conduct and, you know, somebody associated with them, could they be prosecuted under this statute, or would they be able to be prosecuted under existing statute?
I think a similar question was posed yesterday about requirements for the charging. Like all of the rest of the elements of this statute, a prosecutor would need to show that a criminal street gang existed, that a particular defendant is affiliated or associated with that criminal street gang in a meaningful way. There has to be a predicate act, or for this section, recruiting, and there must be a meaningful relationship between those elements. Again, to Representative Miller's previous comment, it is not illegal to be in a criminal street gang. What's codified with this bill and the statute as currently written is that the criminality of the predicate act, the gang, and the affiliation having a meaningful relationship together. A prosecutor would still be required with the bill as authored to prove those elements and to make sure that those are satisfied by the evidence before anything is presented under this section or any other section of 1615-4.
Okay, thank you. Thank you for indulging Waylon Jennings' question too. Number 4, Minority Caucus Treasurer Shelley Roberts.
Thank you, Mr. Chair. So you said the purpose of this bill is to essentially catch the leaders of the gangs, but I'm trying to figure out how you accomplish that without endangering the children that you're trying to protect, because they would have to provide evidence to the judge that they are the leader, I would assume, or they would have to tell the judge who the leader is. Under on line 96, it says the defendant was not a leader. They've got to establish that they aren't, which tells me they've got to say who is, right? And so I don't know a lot about gangs. My world doesn't intersect with them very often, but I know enough to know that that's got to be dangerous for those kids who are going to have to publicly tell a judge who the leader of the gang is. And then it's, it has to be on the record. And so how do you account for the danger that you're putting the very kids that you're trying to protect? How do you account for that?
I think Kara
I hope my
probably
question
can
made
answer this.
sense.
She's prosecuted under the statute more than.
I think I understand your question. So the sections you're referencing are the sort of the deviation clauses, for lack of a
Correct.
better term. So there's 2 options. Both of the potentials for deviation from the mandatory minimums we've articulated are going to come from the sections that you're referencing. So these will only apply when the offense does not involve a child or someone with a disability. So if your recruiting offense involves someone who is over 16, then these will apply. These will sort of kick in. There's 2 options. One will come from the prosecutor in deviation, and that specifically contemplates that the person has helped in a substantial way. And it is purposely written to give prosecutors the tool to be able to articulate via motion to the court, this is how this person has helped. They've given substantial assistance to the state in some way, through proffer, through information provided about other criminal activities happening in that gang. That's option 1. But should that not happen and a judge feel from information available to the bench that it's appropriate to deviate given the particular circumstances of the case, they will go through that series of findings and make sure that those elements are satisfied and then articulate on the record, I'm departing from the mandatory minimum for these reasons, and they could do so in that case. So it's those 2 options. As it pertains to leadership, leadership is going to be a primary target of crimes articulated in this bill because leadership directly and indirectly are responsible for recruiting into the gang, period, but specifically and unfortunately children. So yes, leadership is targeted just inherently by the terms of the bill, but as far as what's required to deviate, there's 2 options, one from a prosecutor, one from the bench, and there's sort of different things in play for both of those deviation options. That answers your question.
So you said that this only comes into play if they're 16 or older.
Correct, if their offense does not involve the recruitment of a child.
Okay. I just thinking about my 16-year-old, and I still see them as a child. And our kid's frontal lobe is not even fully developed until 24. And so I guess my other question is, the governor has made a priority human trafficking as well, and we have recognized that up to 18, if they are caught for prostitution, we're not going to hold them accountable for that because they've been brought into these human trafficking rings and lured in, coerced in. And so I'm struggling to see how these kids being coerced into or persuaded to come into a gang, they're just as immature, their brains are not fully developed. Like, it just seems like the goal of this bill is going to end up scooping up a lot of the ones that you're trying to protect. And so I can't support the bill. Thank you.
All right, thank you. Just one quick question. Who all has a committee and, or excuse me, bill and rules this morning at 9 o'clock. Okay. All right. Well, you know, sometimes you have to go present it for them, so. All right. We got several bills to get to, so just be as concise as you can. Number 18, is that you, Chairman Leverett?
Thank you. Good morning, again. So you mentioned earlier the term enhancement. Is that, just to make sure I understand, are we basically talking about sort of a statutory authorization to impose a more severe sentence based on certain circumstances than what is normally, sort of what is the presumptive range? Is that?
Yes.
Okay.
That's fair.
Okay, so this does provide some enhancements that don't currently exist in law, but for this being passed.
That's right. Yes.
Okay. And I guess I have a question. Are we conflating, because the bill deals with recruitment by gang members of young people into the gang, are we conflating the victimization that occurs of the young person with the desire to punish the recruiter?
Yes.
that's a good way to put it.
Yeah.
Yeah,
So,
I think that's an issue we're seeing it, and that's why I tried to mention in my initial remarks that the mandatory minimums that we're talking about will not apply to a juvenile charged in it. Certainly a juvenile could be charged 1615-4E, but the sentencing structure that we're talking about will not apply to a juvenile offender.
okay. And I mean, I respect the concerns that have been raised. It's the age-old adage, does a bigger, penalty really deter? Perhaps it doesn't, perhaps it does. Certainly it seems to me that we ought to be able to punish people who do this and more severely if they are. So I agree with that general policy goal. If one issue I think was raised in subcommittee about if the recruiters are young themselves, are you then going to be punishing them more severely when they've just gotten into the gang? I think Representative Miller raised that issue, and I think that is a concern. I just wonder if you would maybe comment on that.
So for me, I have to certainly understand that concern as well. Unfortunately, you see in these cases a wide variety of ages on either side of the sort of issues that we're discussing. That's exactly why this bill is a tool for prosecutors. That's exactly why the nexus requirement that we've been talking about, that meaningful relationship between the offenses and the affiliation, they still exist. The prosecutor still must prove those elements, still must check those boxes. And I think most importantly, this is a tool for prosecutors to be able to consider the circumstances of an investigation of a case and determine whether or not bringing this enhancement is appropriate in a particular investigation. Not casting a net over a set of people, but just having the options available to them are the most powerful tools possible, with sort of the caveats and exceptions that we've talked about this morning.
So in other words, based on the facts and circumstances of the case and the culpability of the people involved, it would be a charging decision by the prosecutor as to whether to charge under this statute or something else.
It would, yes.
Okay. Well, one other question, if I may, Mr. Chairman. I know we've got a lot to get to. So my understanding from today, I didn't realize this, is membership in a gang itself is not criminal, correct?
That's right.
Okay. Is there no so if you're in a gang that commits criminal acts, it's not like a conspiracy. You don't have necessarily culpability if you were not actively involved in the particular act. Is that the way the...
I mean, all of the regular things about party to a crime and conspiracy are going to apply, of course, even in the criminal street gang world. But I think what was brought up earlier, and what I certainly agree with, is that it is not illegal on its face to have this affiliation.
Okay.
It's this affiliation with the criminal street gang activity, which I also call the predicate act or the underlying crime. It's sort of all of those elements. They've got to sort of click in together and have a connection to one another. It should not be that we're charging membership in a crime. They've got to have a relationship together.
So I guess to say the status itself is not criminal, but based on what you knew and other sort of elements of conspiracy or party crime, you could have some culpability for something someone else in the gang did in some certain
Sure,
circumstances.
theoretically, yes, yeah, all the same things that we deal with in these cases in the criminal code will apply, but yes, it's just not the affiliation itself is not criminal.
Okay, all right. And I would just say I'm sympathetic to this notion of young people whose brains aren't formed and all that sort of thing, but it just seems to me in a lot of cases, from what I'm hearing from my sheriffs, is these young people are doing some very very mean and horrible adult things, and there needs to be a tool to deal with that and to deter others from trying to pull them into those enterprises in the first place. So, thank you, Mr. Chairman.
Number 12, Vice Chairman Reeves.
Isn't it true that the people who are doing the recruiting, they're often out-of-state gangs, Sewer 13 and Norteños from California, the Bloods, they're looking around where else to do business in the country. And is this an effort to say, not in Georgia, go somewhere else, you're going to get in bad trouble for recruiting young people? And isn't it also true that gangs, they are frequently, everybody in the gang is young. Unfortunately, they're going to die or go to prison at a relatively young age, so they're all pretty young, and they're looking for somewhere in the country to do business other than California and wherever they're headquartered.
And I think what the governor obviously has made clear is there's no room for criminal gangs in the state of Georgia, and that's what this bill intends to do, is to keep them out.
Representative Fleming, you number 5 over there.
Yes, sir, Mr. Chairman. Thank you. I heard this in subcommittee, so I'm ready to vote whenever you get ready. But my comment was that what Representative Reeves said, and y'all can probably verify this, yes, this gang statute, when prosecutors use it and when we give them more tools to use it, is extremely effective in making some gangs not want to be in Georgia. And the example is where I'm from over in Augusta. We had for a while a U.S. attorney and a local prosecutor who worked together. And of course, Augusta sits right next to the Savannah River. And it got so bad that the people in South Carolina were complaining that the gangs were moving across the river to get the heck out of Augusta because of the effectiveness when you're a prosecutor, when we give them tools to use this gang statute, and particularly if you have a U.S. attorney that'll work with them, how effective it can be to get gangs out of Georgia. And all we've got to do is convince some DAs to take these tools, and this special unit of the prosecutors with the AG's office is the beginning of that. And it just so happens that U.S. attorney and district attorney is sitting right there, Bobby Christine, my attorney, who used this effectively to run the gangs out of Augusta over to South Carolina so much that the people in Aiken County next door were complaining. And so if you don't think this is effective, I've seen it be effective, and this is going to make it even better when we pass this bill.
Thank you. All right. Number 6, Representative Neal, good to see you.
Good to see you too. Good morning, everyone. Thank you to the chair. Thank you to the senator. So, and to Chairman Leverett's point, we brought this up yesterday as far as giving an out for those children that just shouldn't apply in here. And then also that was supported by some additional testimony as well. Of changing the and to or on line 101. That was one of the solutions we spoke about. To his point, although I don't support the bill, I don't mind trying to make it better. But with that being said, we were really concerned about the issues that Chairman Leverett has raised, and we were providing some solutions to that. So if anybody's still open to it, changing the and to or is one thing that could address some of the issues that people on the committee have. And I do want to also state that I do appreciate the comment being made about the governor being interested, or the governor's office being interested in going after the motorcycle gangs, the Hells Angels and the Outlaws. They tend to be extremely violent. So I want to thank you for stating that publicly. Thank you.
And thank you, Representative. The governor's office at this point, with that changing the and to an or would really gut the bill and the intent behind the bill, so we'd like to keep that in there, the and. On line 101, I wouldn't be open for that amendment. Thank you.
Robert, what's my friend's name that's the gang prosecutor from down there in the middle part of the state?
Gang resource prosecutor.
also assisting with.
Okay. Let me ask y'all this. Would the AG's office be open to really working with him more in the future? He's got, what, 20 or 30 years of prosecuting gangs under his belt?
Absolutely. I mean, we know Mr. Reagan. Excuse me. I'm sorry. I'm John Fowler. I'm with the Attorney General's office. We already have a good relationship with PAC. They're a wonderful group, and we've worked with Mr. Reagan before, and we'd be happy to work with Mr. Reagan again and again.
Okay. All right. That's a request of the chair. He's really got some good insight, and I appreciate y'all's efforts on this too. Representative Miller.
Thank you. I just wanted to clarify on the question of juveniles who recruit juveniles. Ms. Convery, if under this proposed bill, if there's a juvenile who's charged as an SB 440, so the juvenile is charged as an adult, under those circumstances, if the juvenile is charged as an adult in an SB 440, can the juvenile then be subject to the enhanced penalties under this code section?
I looked at that myself to make sure that I worked all the way through that. Yes, is my understanding. So if you are charged, like you said, SB 440, so murder, act sodomy, all of the things that come under SB 440, and you're charged with a 1615-4E violation, it will. My understanding is that yes, it will travel with the charges, whether it be homicide or whatever else caused that juvenile to be charged in Superior Court, and then that would be applied.
Okay, so if the juvenile is charged with, let's say, armed robbery as an SB 440, and the juvenile under that circumstance, let's say the juvenile's 14, right? 14-year-old juvenile charged with an SB 440, charged as an adult in Superior Court, those juveniles would be impacted by this enhanced penalty scheme.
Yes, could
Okay.
be if a prosecutor chose to bring that. Of course, like everything else, including even bringing that armed robbery, it would be a prosecutor's decision whether or not to charge 1615-4E at all, or to include in a case that has them in Superior Court as a 14-year-old. It would be a prosecutor's choice to do so. But in
Okay.
theory, yes.
Okay, and then because of the enhancement as it's drafted, the prosecutor, is it fair to say that the judge cannot do any departing from whatever charging decision that the prosecutor has made as it is related to this juvenile who's charged with an SB 440? In other words, there's no safety valve. Am I wrong?
No, I think I understand your question. It would not matter that it was a judge still could kind of kick in that clause with the finding of the factors, even though the individual charge was SB 440. The only thing that would matter there that would prevent that sort of valve from being usable is if the individual that was recruited by that juvenile was also under 16. If it was a child, then those clauses just won't apply to the recruitment of a child. I understand that might not be that often in facts, but yeah, that valve is about the individual being recruited, the age of the individual being recruited.
Okay, and last question. The way that our gang statute is drafted, and in practice, the way that it is utilized across the state, oftentimes these gangs have no real national affiliation, and they are not organized by some central kingpin, gang member in California. It's 4 kids who live on Perkerson, and they call themselves the Perkerson Boys. And they might be committing crimes together. Some of those crimes might be serious, some of them might not be serious. But that is what is also the face of criminal street gangs in Georgia. Would you agree with that?
I would say, sadly, here in Georgia, we've got a little bit of everything. We have a meaningful, very serious presence of major national criminal street gangs here, based on the West Coast, based in New York. We've got a series of what I would describe as hybrid gangs that have a local affiliation with either a neighborhood, a street, something very particular, but also claim affiliation and allegiance to a larger national umbrella. For example, sex, money, murder, but they may call themselves or identify as a sort of a local affiliation. That's why, honestly, the problem here feels very unique to me from my exposure to what I have seen nationally, because we have a hybrid concentration, but we also have that major national presence here. these major national gangs, unfortunately, are using the local hybrid affiliations to be able to recruit children. I unfortunately have a case that I can think of in mind where that is occurring. Major national presence, leader is in the Georgia prison system and is using and actually specifically articulating that his members, his high-ranking but street-level members, should go into these communities where there's low-income families and children who are the most vulnerable, and try to scoop them up into this major national umbrella for the protection of that gang. So yes, I would say the sort of scenario you described is not something that doesn't happen here, but we've got a little bit of everything, unfortunately.
Thank you.
I think the concern here, and after having heard this in subcommittee yesterday and now again here in full, under current statute, y'all can already prosecute somebody 17 years or younger if they're involved in a criminal street gang activity. Is that correct?
Yes, a juvenile could be charged.
This is just dealing with recruiting someone under or 17 years or under, correct?
The mandatory minimum enhancement, yes,
Okay,
applies on.
all right. So, okay, wanted to clarify that. All right. Discussion from members of the committee. Number 8. Representative Miller.
So a couple things I want to address. One, to Representative Reeves' point about what these gang members look like and what their options are, I would posit that there is a third option, and that is the option of rehabilitation. And that is the work that a lot of people in our community are doing with these gang members who we are proposing under certain circumstances to lock up for mandatory minimum time to the tune of a decade. Some of these gang members are rehabilitated. Some of them have gone to college. Some of them now work for UPS. Some of them are able to turn their lives around. And my issue with the way that we are approaching this social problem is that we are not focusing on the social circumstances that create gangs. If having a robust, powerful gang statute made us safer and kept people from recruiting folks into gangs and kept kids from engaging in criminal street gang activity, we would have no gangs in Georgia, because we, as far as states go, have the most robust gang statute, and we still cannot get a handle on criminal street gang activity because we will not arrest our way out of it. And we will not imprison a bunch of 17 and 18-year-olds for decades and become safer. The reason why the U.S. Attorney and other folks who have been successful in dismantling gangs, it's not because they have enhanced penalties and mandatory minimums. It's because they have focused enforcement resources. They are infiltrating and arresting. It is the certainty of getting caught that actually dismantles and interrupts criminal activity, and focusing on the few who are doing it in the location that they're doing it with all your resources is what actually makes us safer. So for that reason, I do not think this bill will help. I think this bill will hurt. I won't support it.
Thank you, Representative Miller. Number 5, is that you, Representative Fleming?
Mr. Chairman, when you turn to the committee discussion, I was going to offer to make a motion, so our posture would be that we're discussing a motion. But that's up to Chair's decision if you want to allow a motion
Okay.
right now.
I just want to hear thoughts and concerns from the committee real quick. Number 12.
I'm proud that the governor has been a national leader on fighting gangs, and I know the fight is fairly young, and it's been somewhat successful, as we heard from Representative Fleming. And if the governor thinks this is the next step in that battle of keeping these folks out of Georgia, I think it's a good thing. So I appreciate his leadership and yours, and sending this scourge somewhere else, keeping it out of Georgia.
Number 6. Representative Neal.
Yes, thank you to the chair. I just wanted to echo, like I said yesterday, granted, I do appreciate the efforts on this matter. I appreciate the changes that were provided in the substitute. I appreciate the collaboration, and I can appreciate what you're trying to do. But I am concerned about the unintended consequences, and I'm also concerned about, many probably know Steve Teskey is a judge out of Clayton County, my county, and for many years he worked on this effort. Many people know about that work from 10 to 20 years before, and I consider him to be a great ally of mine. He did a lot of work to reorganize how juveniles are rehabilitated and getting them out of the system. And outside of that aspect, the fact of the cost per head per person by, increasing mandatory minimums, it just eats away at taxpayer dollars, keeping them in there longer. When we can get them out, get them rehabilitated, get them IDs, and get them a job to get them off the taxpayer dime, the amount of money we could save if we would take those avenues is astronomical. So for those reasons, although I do support the effort, especially because of my background, I cannot support the bill for those reasons.
Thank you. Number 16, Chairwoman Ballinger.
Thank you, Mr. Chairman. I appreciate the opportunity to give my thoughts, and I apologize for being late. I was watching it in my office until I was able to come down. I do appreciate the work that has been done on the gang issue. As somebody who is trying to get 17-year-olds adjudicated in juvenile court, I'm very sensitive to the issues surrounding the juveniles. I will say that there is a juvenile court, alternative court for gang members. That is, Judge Glennis is having that in Cobb County, and I hope that will be replicated throughout the state. However, to say that we're going to rehabilitate our way out of the problem is, I don't think, very feasible. And, as somebody who's worked on an issue like domestic violence, we recognize that there are issues that come up and that necessitate new laws and new statutes. And as those issues come up, then we legislate. And we make those policies law, and that's what we do. I appreciate the governor's intention for bringing this bill, and I'm very aware of the juvenile issue. However, I do think that it's necessary for folks on the street to realize that if they get caught, they will be dealt with severely. So I appreciate that. Thank you.
Chairwoman Ballinger, thank you for your added emphasis on that. You're the companion to our committee, and we appreciate you. All right. Representative Fleming, I think you. All right. Got a motion to pass? Second. Motion to pass a second. All those in favor, say aye. Aye. All those opposed, like sign. No. All right. It passes. Well, can you want, yeah. All those in favor, raise your hand. All those opposed, no. Or raise your hand. Okay. All right. It passes. All right. If you got a rule, we got a rules committee form for. I'll sign that and get it to you here just in a second. Senator Payne, Chairman Payne, my friend from Dalton, and no, I'm not running for that seat as that constituent asked you. A little inside joke. Come on, tell us about your bill. Brevity is always preferred here.
Well, I think you'll find brevity very easy to find with this bill, Mr. Chairman. This bill is brought by the Georgia Technology Authority, and right there in the beginning paragraph, which pretty much sums up the bill. And the purpose of it is to require such authority to conduct certain fingerprints, criminal background checks on all of current and prospective employees, contractors, and subcontractors with access to state and federal filed tax documents. And that is the purpose of this, because GTA, they serve on the same servers as some of the federal authorities, and federal authorities say this is a federal requirement that these people that have access to those servers have to have background checks, and so the GTA is just trying to get up to that standard.
Pretty simple. IRS been on y'all, hadn't they, Karen?
Yeah,
Daggum federal government, I tell you. Well, you know what? We'll have to just deal with it under our system of federalism. So, any questions? Say none. Any discussion? Say no discussion. Do I hear a move? All right. Move. Do pass. Second. Second. All those in favor say aye. Aye. All those opposed, no. Y'all want a hand count on that? I'm just messing with you. I'm just joke. It's a joke. It's a joke. We gotta have a little fun. We gotta have a little fun. All right. Congratulations. Do pass. Let me sign this and get it for you.
Thank you.
And always good to see my friend from the mountains.
Well,
you know, just as long as you don't make people in my district worried that there's somebody else running for office.
That's right. That's right. Who's going to be carrying this bill for you in the House?
You are, Mr. Chairman.
That's correct. Yes, that is correct. Yes, I had agreed to that. Okay, well, congratulations.
Congratulations on your good job.
Yeah. That's right.
Keep Representative Carpenter straight. I'll give y'all that responsibility.
Thank you, Senator. Appreciate that. I'll get this to you. All right, Senator Hodges, the governor's floor leader. Good to see you this morning, sir. Tell you what, all these freshmen that have become floor leaders, I tell you what, y'all must have some kind of stock over there.
I think it may be that everybody else who's been around knew better.
May have. What's your bill number and LC number?
Thank you, Mr. Chairman. Bill number, Senate Bill 42, LC is 480718EC.
All right, go ahead, tell us about it.
Sure. Quick and dirty is that SB 42 is it's a governor's and first lady's bill. It is an attempt to strengthen existing anti-human trafficking efforts in the state of Georgia by changing OCGA 16-5-47D1, which was established in 2013 to work against human trafficking. That bill requires posting of information in certain businesses regarding the human trafficking hotline information so that people who may be being trafficked can see this, get a telephone number, and call for help. There are just certain types of businesses that that are required to do this, and I'll be glad to go into those businesses if you want. But this law required this of these businesses, and non-compliance on a first offense carried a maximum fine of $500, and the law said they may be fined, not that they must. And then a second offense, they were to be fined up to $5,000. The first offense, misdemeanor. Second offense, excuse me, pollen in my nose. I'm sorry. The second offense is a high and aggravated misdemeanor. What Senate Bill 42 does is it establishes minimum and maximum fines. 42 would say that the first offense would carry a fine of not less than $500, no more than $1,000. A second or subsequent offense, not less than $1,000, nor more than $5,000. And I'll mention that that you always have a 30-day right to cure. Law enforcement officer comes into your establishment and sees that you failed to post this sign in a prominent position or in a bathroom, then they call you down on it. You got 30 days to cure. If you don't, then you're in non-compliance. This is not burdensome for businesses. This sign is posted on the GBI website. All you have to do is download it, print it, and tack it on the wall. Quite frankly, this bill gives a little more teeth to an effort to take this human trafficking issue more seriously. It is supported by the GBI, by the Prosecuting Attorneys Council, and by the sheriffs. And I'll be glad to answer any questions.
Okay, gotcha. Any questions? Number 14, Representative Byrd, Cherokee
Good
County.
morning. Thank you very much. Thank you. I just want to be sure I understand. So you're talking about that piece of paper needs to be posted in businesses in case there is some sort of sex trafficking going, like in a convenience store or at any other place along the interstate. Is that what I'm understanding?
Representative, I'll give you the businesses that it covers if you like. It's adult entertainment establishment, bars, primary airports, passenger rail or light rail stations, bus stations, truck stops, emergency rooms within general acute care hospitals, urgent care centers, farm labor contractors and day haulers, privately operated job recruitment centers, hotels, And finally, businesses and establishments that offer massage and bodywork services by a person who is not a massage therapist. So, those
Thank
are
you very
the-
much for all of that. So just, I want to understand again, so I'm hanging out in a bar and I've been sex trafficked, but I have not seen a sign in the bar. Then I can call somebody on a hotline and say, excuse me, I've just been sex trafficking, I cannot find the sign.
No
So
representative-
please explain
no
that to me.
representative. The sign is posted so that the person who is being trafficked, the thinking is they might be in one of these establishments for whatever reason. They see this sign, they have a couple of telephone numbers to call to get help about being trafficked. The person that would not see the sign would be a police officer, law enforcement officer, who would go into an establishment, go into a bar, go into the bathroom, go into the break room maybe, and see that nothing like this is posted, and then he would tell the owner that they're in non-compliance, and they'd have 30 days to be compliant.
Okay, and one further question. So if I'm an owner of one of those businesses that you've just named, and I do not have that sign posted somewhere, I can then be fined because I don't have that piece of paper posted. Is that correct?
Well, you can be, but first you would be notified that you're non-compliant. You'd have 30 days to download the sign, post it, and then the law enforcement officer would come back. If you're still not compliant, you could be fined.
Sorry, one other question.
Yes, ma'am.
So is someone specifically assigned to go into all these businesses now to check to see if that piece of paper is posted?
Nobody specifically. I think this is regularly done by police officers, sheriff's deputies, et cetera, law enforcement officers.
Thank you.
Certainly.
All right. No more questions. Any discussion from members of the committee? All right, no discussion. Do I hear a move? I do pass. Second. All those in favor say aye. All those opposed, same sign. All right, congratulations,
Thank
Senator.
you, sir. Thank you, committee members. I
Who's
appreciate
going to carry this for you?
Matthew Gamble.
Matthew Gamble from Cartersville. Hold on a second, I'll get you this to take up the rules. All right, we're adjourned. Oh, we got 40. Oh, excuse me.